Anderson. Is that the one you're here for? A750603, criminal case C268406.
That's correct.
All right, let me read this note my marshal just gave me. Well, I have a request for Mr. Anderson to have a closed-door hearing. I don't have the authority to do that either. It's just the public proceedings, right? And the public has a First Amendment right, and I'm trying to remember the statute. Anyway, it's an open court. I have to keep it an open court for the public to view, so they can report on the proceedings as they see fit.
The reason I say, Your Honor, in the motion to consolidate, I addressed that. I got court minutes from you February 20th, and you did consolidate all of the cases. I have your court minutes here, and I also have the motion to consolidate, and that was addressed in for protective purposes and in the interest of my safety and well-being. It's a lot of things with these issues that are being brought forth that I would like to keep between me and the state. Because
okay, hold on. Everybody who's here now would have the right to be here even if it was a closed-door hearing, except for I don't know who this gentleman in the back is. Sir, can you stand up and identify yourself? Speak loudly, sir.
I'm interested in the outcome of Mr. Anderson's case.
You are interested in the outcome?
Yes.
All right. Well, Mr. Anderson, do you consent to this gentleman being here, if you know who he is? You know? All right. Unusual request. What I can do is close it for purposes of entertaining your request and to see if there's some emergency that would require the proceedings themselves to be closed. All right? So what I can do, sir, is just ask you to step outside temporarily so I can hear the request. If there's an emergency request that has merit to close the proceedings, then you'll be informed on that. If not, you'll be invited to come back in for the actual proceedings.
The only thing that I would say, I'm not sure in what way this gentleman is interested in this case. The only thing that occurs to me off the top of my head is that if he happens to be a victim of one of these crimes, he may have a right under Marcy's law to be here, but I don't know who he is or if that's true.
Yeah, good point. All right, so we are on the record, and the proceedings are closed, and last comment by the DA was made after the gentleman left the courtroom. So I need to entertain your request why we should close the proceedings.
We have, since this research has been done in this proceeding, we have thousands of unnecessary requests and people contacting me, and he is a fellow inmate that has probably been released. And what he wants to do is, they never asked me did they come to find out what was going on with the case. He wants to spy and find out, I won't use the word spy, but he wants to find out information pertaining to the case, so the courtroom could be flooded with unnecessary writs. So he can, it's other people that has found this writ, and the writ has been denied, and back and forth. I've been fighting this since 2011. When he got incarcerated, he was priorly incarcerated with us, and some of the people on the yard found out that the Supreme Court reversed and remanded. Well, they've been trying to get information from me. That's why on 221 I filed a writ of asked for a motion for protective order. Let me get this out now, and then I'll be able to give it to you exactly how it said. In the motion, that was one of the reasons I asked to consolidate. I said, petitioner now placed before the court an offer to consolidate all the above mentioned cases with a gag order for protective order used for stadium, file 221-2018 for the protection of both parties' interests, both citizen and state, to stop millions and millions of unnecessary petitions.
All right. You can only speak on behalf of yourself, not everybody else. The fact that, what might happen with other parties, that's not before me, all right? What I need to know is, would your personal safety, right, of yourself or your family be compromised if members of the public had access to this proceeding? And you're going to tell me how.
I believe that my safety will be compromised because of the research that was done. And me even making it this far with this particular writ, everybody wants a piece of it. And I haven't had any rest for the last 2 to 3 weeks. People who've been released, all they're thinking about is, are we going to make this kind of money? Are we trying to get to nail the state? And what I told them was, no, I've already asked the court to place a gag order on this and then go unpublished. And no one that's not a part of this proceeding be allowed in the courtroom.
Okay, let me hear from the district attorney if he would like to respond to that.
I mean, given the representation that this gentleman's not a victim, the state doesn't really have a position. We'll submit it to the court.
Yeah, I'm not going to close the proceedings. There's not good cause, as you explained it. Thank you, sir. I'll ask the gentleman to come back in. The proceedings are now open. Let's wait until the gentleman has the opportunity to come back in. Give me a moment to read the minutes from the last proceeding. All right, so at the last hearing, I had ordered that the petition, to the extent it challenges the time computation, was dismissed as the matter must be heard in Department 10. The court also noted that your challenge to the constitutionality of Senate Bill 182, to the extent it might affect your conviction, would be heard by this court. I directed Mr. Neiman to file a response or appropriate motion within 2 weeks, and defendant to file a response 2 weeks thereafter. The court ordered the matter continued for hearing today. So let me ask counsel, do you have a position on this?
In terms of the underlying petition?
Yes.
Yeah, I mean, to the extent that the court's taking a look at our response, I think that
Yes.
outlines everything. I'm happy to entertain any questions the court has, but beyond
No,
that, I don't have
has
an
it-
argument.
Has it been provided? 'Cause I have his reply. I didn't know if you guys wanted argument on this, or you wanted me to just resolve it on the papers. Since this is your motion, you can decide first if you want to speak, or if you want me to just decide it on the papers that I
I
have
would like
reviewed.
to address the court.
All right, so I'll go ahead and let you speak, and then the state has an opportunity to respond if they wish, and then you can speak one more time if the state has spoken, and then I get to make my decision. That's the procedure we follow. Do you understand?
Yes, sir.
All right, you get to go first.
I would like to address, on February the 5th, at the hearing, the court gave strict orders and instructions to the state to respond on how the constitutionality of Senate Bill 182 would have affected my conviction. Well, unfortunately, the state did not respond. The state totally disregarded that order and again attempted the use of latches, time bars, and procedural bars. When you're addressing jurisdictional issues, or should I say subject matter jurisdiction, there is no such thing as a time bar, a procedural bar, or a latch. Therefore, the court must take everything in this writ to be true and correct, because there's no opposition to anything that was said in this writ. There's no opposition to the unconstitutional creation of Senate Bill 182. There's no opposition to violations of 6, 11, and 12 of the Nevada Constitution. There's no opposition to violations of 3 and 1, separation of powers. What the state attempted to do was throw the court off its axis and direct the court to a response from Judge Kathleen Delaney, which in that response, the 8th District Court had divested jurisdiction of the case because the appeal was filed 3/5/18, and there was not a remitter submitted till 9/11/18. So during the time that the Supreme Court had jurisdiction of the case, how did we attempt to rule on something that's not even in your jurisdiction at this time. The state brought that up, so again, I would like to reiterate to the court that that entire response from Kathleen Delaney be stricken from the record as moot, null, and void because she never had jurisdiction. And again, in that answer, the state never addressed the constitutionality of Senate Bill 182. Your Honor, we live on the most powerful country on the face of the earth, with a group of laws created by some of the most powerful lawmakers on the face of the earth. How is it that constitutional violations continue to happen and the state turn their face to it like they don't exist? The oath of office they took said they swore to uphold the Constitution of the United States of America from all enemies, being foreign or domestic. They swore to uphold the Constitution of the latter from all enemies, being foreign or domestic. Well, we have a domestic enemy here, or should we say we had a legislative breakdown in 1951? Either way, it happened. It's here. And my incarceration is a direct, not something on the side, this is a direct result from that legislative breakdown that took place in 1951. I'm not concerned about what anybody else did or the research they did. I know what I found to be true. I found, first of all, violations of the 9th Amendment of the United States Constitution. Not the First Amendment, not right to redress the government because you've given me the opportunity to redress. Not cruel and unusual punishment, not the 14th Amendment, but the rights retained by the people cannot be infringed upon. When our rights become infringed upon, when these rights, Your Honor, become infringed upon, we forget about decency, security, and liberty. These are like demands that government officials shall be subject to the same rules of conduct that are commanded to the citizens. In a government of laws, existence of government will be imperiled if it fails to observe the laws completely. Our government is the potent, omnipresent teacher for good or ill. It teaches the whole people by example that crime is contagious. If the government becomes a lawbreaker and disregards the Constitution, it now breeds contempt for law. It then invites every man to become a law unto himself. It invites fraud to declare that in the administration of criminal law, the ends justify the means. To declare that the government committed crimes in violation of the state constitution and continue to overlook these crimes in order to maintain and secure an unconstitutional conviction of a private citizen will bring terrible retribution against the precious doctrine called the Constitution of the State of Nevada, as well as retribution against their precious oath of office. That's why I'm here today.
No, I understand, and you had much of this in your papers. I appreciate that. So you'll have a chance to have the last word after I see if the state wants to respond to that. Okay?
Sure. So one of the issues that we raised was that it was barred by res judicata based on Judge Delaney's order. In the response, Mr. Anderson did state that that's not the case because it was up on appeal. However, I think the Nevada Supreme Court's been very clear in its Honeycutt, H-U-N-E-Y-C-U-T-T, the Honeycutt. The district court only had the power to deny the petition, which the district court did. The court had the power to do that, even though it was up on appeal. If the court was going to grant the petition, there's a procedure in Honeycutt that the court had to go through. But the fact that it was up on appeal was no bar to Judge Delaney's jurisdiction to deny that case. Other than that, I mean, the fact that it's simply not true that procedural bars don't exist. They're enacted in the Nevada Revised Statutes. This is a petition for writ of habeas corpus to the extent that it challenges the jurisdiction. It's time barred, it's excessive, it's an abuse of the writ for all the reasons we outlined. The fact that it was also barred by res judicata was something that we didn't find until we did go back and research it, because we had to look at the variety of petitions that have already been filed in numerous different courts. And beyond all of that, if what we're talking about is the unconstitutionality of a statute, that is squarely an appellate issue. It must be raised on appeal if it's going to be raised at all, not in a petition. So this petition should be denied for all of those reasons.
Thank you, sir. All right, you get the last word on this, the last explanation, Mr. Anderson.
Okay, I gotta give you a second, I'm handcuffed here.
I understand.
Your Honor, it's abundantly clear that this writ is appropriate for a new action being brought forth in the civil arena. However, to provide authority to this statement, petitioner relies upon decisions of the Supreme Court found in Snow versus State. Snow versus State opinion that the writ of habeas corpus is available to allow the presentation of questions of law which cannot otherwise be reviewed or that are so important as to render ordinary procedure inadequate and justify extraordinary remedy. See the records of prisoners. Also see Osborne versus Flanagan. Snow versus State does not delineate a post-conviction writ of habeas corpus, yet it only delineates a habeas corpus. This reason is very sound, as the court expressed, to allow the presentation of questions of law which cannot otherwise be reviewed. The questions of law presented in this writ, which could not otherwise be reviewed in other than Snow, concerns the facial constitutionality of Senate Bill 182.
All right, sir. So, sir, you are obviously well-versed in the Constitution, and I have, respect for that, and you obviously have a lot of respect for the rights of the people, and, in this country, appreciate that, sir. Unfortunately, you have had more than one opportunity to raise these issues. These are issues that were supposed to be raised on appeal. I don't have the authority to consider these issues once you had an opportunity to have them heard on appeal.
They were raised on appeal.
They were raised on appeal. No,
and they were sent back to you for procedures. I have that, exactly what the Supreme Court said right here with me today. These issues were raised on appeal. They were reversed and remanded back to you, Your Honor.
Well, the reversal, let me just double check that, because I remember, I don't think it was reversed for purposes of determining the constitutionality of 182, but I'll just double check that.
It was reversed.
Because it would be the Supreme Court that would make that decision. Let me just double check, hold on.
Here it is right here.
All right, Marshall, will you help me?
It was reversed because they never heard it. Every time it comes before the court, they find a way to get rid of it.
I'll double check, I'm going to double check. Trying to recollect the context in which this was raised. Give me one moment. Let me ask counsel, was the Judge Delaney decision, was that one separately appealed?
Yes, it was. I have that paperwork.
Hold on.
I'm not sure, but I'll accept the representation if it was.
Have you had a chance to, why don't you show that to counsel?
I can show you the exact dates.
That's for the, yeah, go ahead.
The last time I was here before you concerning this writ was February the 6th, 2018. They told you that I wasn't transported. I don't know how.
I remember that.
And I was in a holding pen. They didn't let me come out. 2 days later, I have the order, not from you, from the original judge that was on the case, and she dismissed it. Her name is Lori. She dismissed it. Let me find it so I can show it to you. It's kind of hard to work my hand. She dismissed it. Here it is right here. She dismissed it on the same grounds that she dismissed it on the first time, stating that the state wasn't served. Well, I appealed that on the 5th, and then 2 weeks later, I get a notice from you saying that the writ was going to be sent to be recharacterized as a criminal writ. I appealed that, and the Supreme Court informed me that this was already under appeal number 75313, which 75313, I have a remitter here. It wasn't issued until September the 11th. So during that time frame, I appealed both issues before Delaney was involved. I appealed when you sent it back and when Judge Lori sent it back. I have all the paperwork here to...
No, I have all the paperwork
Okay,
here.
I'm sorry.
Looking on the
Well,
computer.
while the case is on appeal, Judge Delaney rules on the case, which the 8th District Court no longer have jurisdiction. She rules on the case that's already being decided by the Supreme Court. And the date of that hearing was May the 14th. Here's Delaney's response.
What's the Delaney case number?
It should be the C number, I believe, C10-268-406.
All right, very good.
Did the court notice when the Supreme Court sent it back, they sent it back under the civil number?
Yeah, no, I know all the facts of what happened in front of
I'm
me.
not trying to be disrespectful.
No, in front of Department 2, I have all of that.
I'm not, pardon me, I wasn't trying to be disrespectful on you.
I didn't take it that way. So what I'm trying to do is look at exactly what Judge Delaney did. Thanks for your patience. So I see the date of your appeal from the judgment of conviction before Judge Delaney, and then the Supreme Court dismissed the appeal. I'm trying to find out the reason why.
I think it was, when they first sent it back to you, Your Honor.
This is, it would have gone back to Judge Delaney at that point in time. Or actually, there would have been a remitter back to her for purposes of closing the case.
Is this around the February 8th, 2018?
No, this is the first one. This is the 2013 appeal.
I have the Supreme Court order if the court would like that.
Yeah, is that the 2018 appeal or 2013?
This is an order filed on September 18th, 2013 from the Supreme
Oh,
Court of
let me take a
Nevada.
look at that one then. Thanks.
That's a totally different writ, Your Honor. That's not this writ at all.
Hold on. So I was under the impression that your first appeal had raised two issues, and if I'm mistaken, both you can let me know. I thought one issue was ineffective assistance to counsel, and the second issue was the unconstitutionality of the Senate bill. Did you raise both issues, or just one of those? That's the appeal of your conviction.
I don't think the ineffective assistance of counsel would have been raised on appeal because ineffective assistance of counsel is a post-conviction. You have to file a writ basically for ineffective assistance of counsel. You can appeal the denial of a writ for
Okay.
ineffective assistance of counsel.
That's what that's what he did here. You denied, or the Supreme Court denied, the Supreme Court denied your argument that you didn't receive effective assistance of counsel.
That was on my direct appeal. That wasn't on it. The argument with the direct appeal, which is in the Ninth Circuit right now, Your Honor, is not that it has any bearing, but to bring you up to date. What me and counsel was attempting to find out is how was I sentenced on count 2, and I was exonerated on count 2. I was exonerated on count 2, and the case that they used was George Morris versus Everett Reynolds.
You don't need to know that. All I'm trying to determine is
Okay.
when you first raised the issue of unconstitutionality of the statute.
But when I first raised,
I'm trying to find out when you first raised it, so I can see the procedural context in which it got to me.
Okay, I got it. You need I think I got the cover sheet too. I do, anyway, I do.
Counsel, if you know the answer to that?
I don't. I don't know that the constitutionality of so 182 was raised on appeal at all.
But your position is that, which is what I believe is correct, you indicated that that's an issue that should have been raised in his initial appeal from Judge Delaney's conviction.
Correct, right. The constitutionality of a statute is an appeal issue.
Right. No, and I agreed with that, but then Mr. Anderson here was suggesting that the Supreme Court didn't affirm the conviction, that they remanded it back to Judge Delaney for further proceedings, and I don't see that mentioned here.
I think that 2013 appeal is the first appeal.
The 2013 is the direct appeal.
Correct, right, from the judgment of
That was
conviction.
direct appeal from.
So that's the first appeal.
Right, that has nothing to do with this at all. I'm trying to, I have the cover sheet on the first time this was sent. That's it.
Give me a moment, I'm still reviewing the Supreme Court's
Sure.
written decision from 2013. Just hold on a second. All right, so just so we're all up to speed, all right, when you filed your appeal to the Supreme Court in 2013, challenging the conviction of Judge Delaney, you raised certain. I'm sorry. Well, it was Judge Delaney who denied the post-conviction petition for writ. Okay, so at that time you raised these arguments. Number one, that counsel's performance was deficient. The Supreme Court denied that claim. You said that your plea was coerced. Supreme Court denied that. You said that you were promised probation, didn't receive that. Supreme Court denied that. You claimed that you weren't told that your attorney was closing his law office. Supreme Court denied that. And you claimed your counsel had represented he would file a notice of appeal. The judge didn't conduct an evidentiary hearing on that issue, so the Supreme Court reversed on that issue for that limited issue and remanded it back to the district court to conduct the evidentiary hearing. All right, so what we have is we don't have constitutionality raised in connection with the post-conviction petition for writ of habeas corpus
Which would be
appeal.
correct, because even in that first petition for writ of habeas corpus, it's not an issue that should have been brought in that petition, so
Right,
it shouldn't have been appealed from.
So I'm looking backward in time further
Mhm.
to the initial appeal. So we must have had the appeal
I don't believe there was a direct appeal from the judgment of conviction. I think that there was only an appeal from the denial of a petition for writ of habeas corpus, which was the 2013 one.
It was a direct appeal from the JLC. I got a Lozada appeal.
Oh, I'm looking.
They gave me the appeal on Lozada issues.
So I'm just looking at the procedural history that was written when I had a chance to have all of this in front of me. February 29th, 2012 was Mr. Anderson's sentencing, and I believe the judgment of conviction. March 9th, Mr. Anderson filed a motion for reconsideration of March 9th, Mr. Anderson filed a motion for reconsideration of sentence. The judgment of conviction was filed on March 14th.
Of
2012.
March 14th, 2012.
Correct. On April 23rd of 2012, Mr. Anderson filed a notice of appeal.
I see that. There's a notice of deficiency. I believe that was cured.
Yeah, I'm a little, you guys lost me here. I'm trying to figure out what does the criminal appeals have to do with the writ that's before the court now. I can't get an answer on this writ. The state refused to answer it. Every time it's before the state, they refuse to answer it. We find ways around answering this writ. And I'm dumbfounded. I'm asking why. I didn't go to Yale or Harvard or Stanford or no big fancy law school, but I could read a little bit.
So, I mean, what I would inform the court is that basically this is just the wrong vehicle to bring this claim. it should be raised in an appeal to the court. You know, what the court would do with it or what the state would respond, I'm not going to speculate at this point, but it's not a petition for writ of habeas corpus issue. It's an appellate issue. It should have been filed right after the judgment of conviction because all the facts and circumstances were available at that point.
Well, that's what I'm still trying to find out.
Sure.
The date of the appeal and the Supreme Court resolution of that appeal. Just confirming the Supreme Court resolution of the 2012 appeal from the judgment of conviction. Sure. So let me just find that. Taylor, put something up for me. Let me give you the case number, okay? Just a minute. Looked at it. I'm pulling up the Nevada Supreme Court files on this
Sure.
from the case number that I have for them, Supreme Court case number 60723.
I was going to
Guys,
say,
go ahead and have a seat.
I think that on the Supreme Court Court of Appeals website, searching by the party will bring up all of the appeals that person's a party to.
The first appeal is an appeal from the judge's decision denying a motion for reconsideration. And that was, who was the judge at that time? Guys, I'm still not finding the original appeal. It looks like you guys can't help me out on that. I'm going to just have to take this under advisement. I'm trying to find the original appeal from the judgment of conviction. I see appeals of all sorts of other things. But the bottom line is, you're required to raise the issue of the unconstitutionality of the statute in your appeal from your judgment of conviction. All right, that's what I started to say originally. And if you did raise it and the Supreme Court rejected that argument, that's the end of the story. If you didn't raise it, you should have, that's the end of the story. Right? If you did raise it, you know, the end of the story means I don't have jurisdiction to reconsider it. If you did raise it and the Supreme Court, for some reason, remanded it back for some further proceedings, then I need to look at that. So that's why I'm trying to follow the course of the history of this issue. Okay?
Okay. What I'm trying to figure out, Your Honor, with all due respect to the court, the original appeal from the judgment of conviction, I had to go back and have an evidentiary hearing because
Ineffective assistance
of counsel, because I brought certain issues to Mr. Whipple's attention, and Mr. Whipple said he didn't recollect on the stand. I didn't get a direct appeal for almost a year and a half after the conviction. I've been fighting this, and a lot of these issues that I did not have, like I iterated to the court. I'm not an attorney.
So what you guys haven't told me is the case number for your direct appeal.
The
right?
case number for the direct appeal.
Right, from the judgment of conviction.
I don't have that.
Okay, all right. Well, I'm going to look it up.
Okay.
All right, because I need to double check, see what the Supreme Court's resolution was on that. All right?
Before the end of today's hearing, can I want to ask you to make sure my comprehension is totally where it's supposed to be. Because right now I'm having some different kind of feelings that I'm not understanding. Because on the 5th, you clearly stated that the state was to answer the challenge to the constitutionality of Senate Bill 182. We addressed latches, time bars, and procedural bars at the first hearing. We addressed all of that, and in your minutes, you said the court further noted the defendant's challenge to the constitutionality of Senate Bill 182 as it might have affected his conviction should be addressed. We're not addressing that, Your Honor. I feel like we're going all the way around the field and we're not addressing the reason I'm here. The reason I did not have knowledge of everything that happened.
The minutes are not precise. First of all, they're prepared by, you know, the clerk, which is a very good recollection of what we discussed here. It's not an order of the court. In any event, the minutes are substantially correct. We set down this hearing for purposes of considering your request for the court to find the statute unconstitutional. So that's why we're here. The state has taken the position that I shouldn't reach the merits of the issue because there are some procedural bars. All right? So one of the reasons why we're here is to allow the state to respond to your request for me to resolve the issue of constitutionality. I didn't mean to order them, and it wasn't my order for them to actually come forward and explain whether it's constitutional or not constitutional. They were only supposed to reach that issue if they felt that it was properly before me. Does that make it clear for you now? Because they're saying that I don't have the authority, the jurisdiction to rule on the constitutionality at this point in time, that it's not properly before me. And I wanted to hear their position on that. Okay? Should be clear.
In both responses, they're identical. Delaney's response is identical to the res judicata that the state just initiated. Both responses are identical, Your Honor. They will not address the fact that they violated the Constitution. You can't hide from the truth.
Well, I'm going to carefully consider it, sir. I'll make a decision if it's properly in front of me. But if the Supreme Court already decided it, if Judge Delaney already decided it, or if you could have put it in your appeal and you didn't, then, you know, all those things, then I don't have the jurisdiction. I don't need to hear any more on this. I appreciate your position, all right?
So the consolidation, you put, my civil case in front of you, and you put my, calculation of time in front of you also.
Calculation of time is not in front of me. I dismissed that if you refer to the same minutes that you were just reading from.
No, those are, these minutes are from the 5th. I did receive minutes from this courtroom from February the 20th. And the Supreme Court is aware of it because whoever, you said you didn't do it, but the Supreme Court sent me paperwork showing that all the cases were consolidated also. And I have that because I was supposed to hear from the courts on the 14th or actually be physically in court on the 14th for the minutes. And, I mean, for the improper calculation of time.
Okay.
And that didn't happen.
Well, in any event, improper calculation of time is not before me, right? It has nothing to do with constitutionality of the statute we're talking about. So, I'll look at the merits of your claim. I'll look at whether I have jurisdiction over your claim. If I do have jurisdiction, then I'll go ahead and decide the issue of constitutionality, okay? I'm not expressing any opinion on that now. Okay? All right. All right, I'll take a look at this a little more carefully and then let you guys know.
Appreciate
All right.
it.
Thank you, guys.